Good day, all. This is Judge Karen Howes, Judge in Residence at the National Council of Juvenile and Family Court Judges, and I'm joined by
Connie Hickman-Tanner, the Chief Program Officer here at the Council.
We're going to explore with you all today the intersection between child welfare and domestic violence, from the Greenbook to Family First. I don't know how to do this. All right, first let's talk about the objectives for this session. As a result of this webinar, you should be better able to examine the efforts to forge stronger communication and more effective services in cases that involve child maltreatment and domestic violence through the lens of the Greenbook. You should also be better able to understand, identify, and discuss key provisions of the Family First Prevention Services Act of 2018 and the policy changes that may be used in child welfare cases involving domestic violence. We also hope that you'll be able to discuss strategies in your community to build bridges and improve outcomes for families involved with child welfare, where domestic violence also has occurred. So let's ask this question first, if you would respond to the poll. How many of you are familiar with the Greenbook, which actually title really is Effective Intervention in Domestic Violence and Child Maltreatment Cases, Guidelines for Policy and Practice, but it is commonly known as the Greenbook. This is very helpful. All right, let's go through what the Greenbook is to give us some context. It was published in 1999 by NCJFCJ, and it was a collaborative process that engaged in dialogue and practice development between child welfare professionals, the courts, judges, and others, academics, attorneys, and domestic violence advocates. It was launched to respond to the fact that 1998 research showed that 30 to 60% of child abuse and neglect cases across the country also involve some domestic violence. It was also designed to be a guidepost for communities working to address the co-occurrence of child maltreatment and domestic violence. In the end, it provided a set of principles and recommendations for the main systems involved: child welfare agencies, domestic violence service agencies, and the courts. The Greenbook's goals. The goal set by the advisory committee was to establish a response to address the research of the high number of cases in child maltreatment that also had co-occurring domestic violence. It was also a goal to encourage systems to address these issues of the intersection of child maltreatment and domestic violence through the use of collaboration to improve practice, services, and outcomes for children and families. Now, as a result of the publication, there was also a year of demonstration projects in select locations throughout the country. And the results of those demonstration sites included the creation of specialized positions within child welfare agencies that involve bringing domestic violence service providers and the court into play to enhance information sharing and improve services for children and families. These specialized approaches were required to work with children and survivors rather than seeing them as separate and unique. We see that there are a number of people on this webinar who are from the domestic violence advocacy community. And one of the things that came from the demonstration sites work was the identification of better intervention programs that should have been and should still be critical partners in the collaboration if change is to happen. The sites also described other efforts to increase accountability of those responsible for the violence, including those specialized agency positions, outlines of court system best practices in these cases of co-occurring abuse, and safety audits to assess criminal justice system responses to domestic violence in relationship to child welfare cases. But we have to clearly understand, and I'm sure many of you still experience this today, that there are different tasks for different disciplines. So, child welfare, they were responsible, and still are, to determine whether the safety of the child is achieved. And that includes decision-making about whether the child should be removed from the home. The DV advocate community assisted in finding safe housing without the need to separate the child from the victim. But the victim or survivor was the primary goal of the advocacy community. Different missions. We can see that. Child welfare, their goal was to protect the child, ensure permanency, child safety and well-being, safety planning for the child. There wasn't a lot of work around safety planning for the survivor parent. On the same side, on a different side, DV advocates were required to assist victims in creating a safety plan, assist victims in seeking protection orders, and support victims through any criminal processes that flowed. Meanwhile, the courts had a panoply of responsibilities. Victim safety and autonomy in civil DV cases, perpetrator accountability in civil and criminal DV cases, safety, permanency, and well-being for children in child abuse and neglect cases. All had the mission during this exploration that led to the Greenbook for race and cultural bias, that a mission to engage in discussion and practice to eliminate race and cultural bias in all of these cases. What the Greenbook did not do. It's very clear, and people acknowledge that critical partners were not at the table. And that critical partner group was the batterer intervention programs, or people who had been engaged and transformed themselves from being responsible for the violence. So let's talk about DV and child welfare. There is considerable evidence today that points to the fact that domestic violence and child abuse do often co-occur. In many of the presentations that Connie and I do, we ask the audience, often judges, often other professionals, advocates, as well as child welfare professionals, what percentage of your cases today, not 20 years ago, do you see that involve a co-occurrence? We often get numbers up to 60, 70, and 80% of the cases currently that flow through the courts or the system. We already talked about the numbers in 1998. Nothing much has changed despite the seminal efforts that resulted in the Greenbook. We also know that children exposed to domestic violence are at increased risk for physical abuse and other forms of child maltreatment. And we cannot ignore the fact that violence has an impact on trauma for children and families. Co-occurring child maltreatment and domestic violence often exists in the presence of other risk factors, such as poverty, parental unemployment, substance abuse, mental illness, crime, financial or parenting stress, poor health, and lower education. Caution does have to be used when drawing conclusions about the existence of these risk factors in families with co-occurring violence that are involved with the child welfare system. The studies that have been done show associations between variables, not cause and effect relationships. A resource for these discussions, not only NCJFCJ, but the Resource Center on Domestic Violence, Child Protection, and Child Custody. Now, someone has asked how to obtain a copy of the Greenbook. They are available through NCJFCJ. You can also tap into our website to explore asking for a copy. They're available at no cost.
You can download a copy immediately by going on the web page, or you can simply email us and we can send you a hard copy. We just celebrated the 20th anniversary of the Greenbook, so it does include some best practices. So please feel free to contact us to get a copy of the Greenbook. As we see many people, thank you, Amber, for putting the site on how they can get the Greenbook.
Now we're going to move on now to a discussion about Family First. Connie?
So how many of you are familiar with the Family First Prevention and Services Act? So it seems like we've got about more not than are. So hopefully we'll be providing you some information that will help you with that and showing you some of the bridges that we think will be available to help your cases, your child welfare cases that involve domestic violence through this new act that was passed in 2018. So we're going to start with, if I can figure this out. We're going to start with kind of the big picture, which is really the big picture for child welfare since the inception, but actually there's some more provisions that I think are in this act that actually are there to make this meaningful. It is designed to keep children with their families and to ensure that if they are removed, they're in the least restrictive, most family-like and appropriate-like setting that meets their needs. It also really focuses on family and youth engagement. One of the most exciting pieces about this act is that they have a piece that many of us have thought the child welfare system funding, the Title IV-E funding, went in only when removal occurred. And many waiver states were allowed to use that funding in different ways. The states that use waivers, that ends at the end of this fiscal year. So what this act does is it allows states to take up to 50% of their Title IV-E money and use for prevention. Now I will tell you, it says prevention, but I really think it's more like intervention because you have to be known to the agency. But the prevention funding can be used for mental health services, substance abuse prevention and treatment services, and in-home skills programs, parenting skills training, parenting education, individual and family counseling. So these services can be provided to prevent coming into foster care. Now, while these services don't specifically address domestic violence, and it doesn't say that in Family First, those services, as many of you know, are services that a lot of our domestic violence parents need. And as long as they meet the criteria, they can meet the needs of a lot of our families. So what's the criteria? Who's eligible for services? So who can get these services? It's a child who is a candidate for foster care. So a child who is a candidate for foster care is any child who's at imminent risk of entering foster care. And the feds have not defined imminent risk, and they do not plan on defining imminent risk. It is also not with regard to the eligibility requirements that the maintenance payments regard to. So there's no income requirement like the AFDC requirement. It also includes a child in foster care who's parenting or pregnant, and parents or kin caregivers of youth. And for those requirements that I mentioned, anytime the federal government gives funding, there are always federal requirements. And here are the requirements that you have to have in order to draw down those prevention funding. Now, for those of you who've heard of Families First, the most talked about requirement is this evidence-based and promising supported and well-supported practice. So, the Children's Bureau has contracted out with a clearinghouse to go through and identify those programs that meet that criteria, set up that criteria, and determine which practices meet that. And going forward, here's just a kind of a brief overview of what that criteria entails. Bottom line, you've got to have some rigorous evaluation of your programs to show that you meet this criteria. As you see, the most rigorous is the well-supported criteria, and you have to have 2 control experimental groups that you have done and sustainability for 12 months. The other piece that is important to know, that 50% of all your programs have to come from well-supported programs. So this is a very high bar that the federal government has said, if we're going to fund these programs, they have to be evidence-based from well-supported programs, at least 50% of them. There has been a delay in getting some of this done, and so they are working on some pieces to help with that. As of just a few days ago, they are still working on these, but this is still correct. Well-supported programs that have been approved include these programs. Some of you may recognize many of these programs. Some of the most familiar are multi-systemic therapy and functional therapy. Also, I hope some of you are familiar with the Nurse-Family Partnership that I think has been evaluated a lot by Chapin Hall and others, where nurses go in and as soon as a child is born, they go in and work with families to make sure that they have support systems. So these programs have already been identified as well-supported programs. If you go to this website that I've given you the link to, you can actually read about these programs. And so this funding would be available. You could have drawn down as of 2018, but not be reimbursed as early as October 1st, 2019 for states that are going for this funding.
Connie, can I just clarify that all of these things about the supported programs, this is what your local child welfare agency will be responsible for. So I've been looking at the number of people on this webinar who are from the advocacy community.
Right.
It is worth it to keep up with this because it will be through the well-supported, supported, and promising that services appropriate to victims of domestic violence who are engaged with the child welfare agency will be able to plug into these services and avoid removal.
Absolutely. And one of the things to find out, how your state is doing, we get asked, how can I find out what my state's doing on that? We encourage, finding out who, contact people at your child welfare department, your child welfare director, your CIP, your court improvement program, and find out what's going on in your state. Here are your promising programs that have been approved already. Also, the Children and Families has issued an instruction for transitional payments because things have not rolled out as quickly. You can have transitional payments while things are in the pipeline to be approved with the clearinghouse, and this website, this site provides for how programs can be submitted to be approved, and as long as they're submitted, there can be transitional funding until they're approved. But the government is not backing off on the evidence-based programs and their criteria to go forward. So these are some states that we know of that are going forward. As I said, the funding for reimbursement for the prevention programs is available October the 1st, 2019, and can go back for reimbursement as soon as 2018. So these are states we know that are moving forward. Another huge piece to this that we're not covering today is there's a piece in Families First on congregate care that has a lot of requirements for Title IV maintenance payments that the agency and the courts are responsible for. And states and courts must comply with those provisions before they can draw down the prevention funds. They have 2 years, they can waive that provision up to 2 years, but must be in compliance within 2 years. Prevention funding is optional, but they cannot delay the congregate care pieces. So some states are not able to draw down the prevention funds because of the restrictions on the congregate care pieces. So another piece to find out is when your state is moving forward with your prevention funding, because we want to go forward with that. As you'll see, some of the big states like California, New York, Texas aren't on this list. They have a lot of kids in congregate care. I see that we have a comment that Cleveland sure needs this. Yeah, every state needs this. So we encourage you to talk to your state about what they're doing to move forward and to be engaged, to find out what kinds of programs your domestic violence victims and survivors need to make sure you're getting the services that you need.
Another area of the Act that we want to inform you about is Reunification Services. So, you know, these services are detailed in the Act, and it allows Title IV-E foster care maintenance payments to be made on behalf of a child in foster care who is placed with their parent in a licensed residential family-based treatment facility for up to 12 months. This, as with the prevention services, means that many folks that you may deal with may not have to be separated from their children, or their children may not have to go into foster care even for brief periods. Reunification services also are available for up to 15 months after a child returns home. And the return home date and the clock starts running at the date that the child is returned home.
And this is available now. So these are things that are available now for your families.
So the other area is exactly what services, as Connie talked about with prevention, what services are available under the reunification provisions. Of course, individual, group, and family counseling, inpatient residential or outpatient substance abuse treatment services, mental health services, and this one is delineated for the population we're talking about today. The Act says specifically, assistance to address domestic violence. What that looks like, we don't know, but this is an area that you all as advocates for survivors have an opportunity to impact the services that are provided in your community. Also, services designed to provide temporary child care and therapeutic services for families, including crisis nurseries. This is a big one. This is a move that is happening in not only child welfare, but also within the legal community, attorneys who represent parents and children in child maltreatment cases, and also actually in domestic violence cases. This is an opportunity to bring the persons responsible for the violence into the process. These are peer-to-peer mentoring and support groups for parents and primary caregivers. Now, these peer-to-peer mentoring service providers are usually people who have experienced the system in whatever form, and they provide a support to help the parent get into the groove of complying with prevention or reunification services as quickly as practicable. Services and activities also are available that are designed to facilitate access to and visitation of children by parents and their siblings. Also, which is a big deal in many communities, transportation to or from any of the services and activities provided under the reunification rubric. Now, after reunification, there are other provisions that help to bridge the dynamic that exists with child welfare, but also at the intersection of child welfare and domestic violence. After reunification, if a child is at imminent risk of foster care again, but can remain safely at home or with their relatives, the family may again receive prevention services. And this becomes a game changer in many respects once the implementation process is completed. So this is a fluid process. It is not, you go back once, you can't come back again. Now, child welfare agencies must engage with persons identified by the family to be involved, including relatives and other community members that they wish to bring into this circle. The idea here is, and this is true with the congregate care piece that we're not going to talk about today, the idea here is that the children and their families, their whole families, they run the show. And that is not what we have had in the past.
Other opportunities, other than really leading with evidence, is one of the pieces that Judge House and I really stress when we do training all across the country, is the opportunities for data collection, and really on the intersection between DV and child welfare and the effectiveness of the programs. Very few places collect even data on how often the child welfare system has components of we have anecdotal data. Even when we ask judges, they'll say an estimate, but they don't collect this data. So we can better know how to provide the appropriate services for the people before the court. And we think it's critical on a number of ways, not only for knowing how best to provide services for the people before them, but also to think about services needed that might prevent them from coming to court to begin with, particularly with this area of the prevention services, and to collaborate better to identify these services to meet the needs of the communities of color and marginalized communities.
Now, one of the things that I think, especially looking at the composition of the audience here on the webinar, the importance of data collection cannot be diminished. One of the things that is very interesting, if we ask people, regardless of the discipline, how many of your cases have DV, we really do want to differentiate whether that was the reason for the call to child welfare or whether it was just an element in the family dynamic. Because those two differences will change it should change the response that is provided to that child and that family.
One of the other opportunities, and one of the big opportunities, especially we've really been challenging judges with, is the anticipation and the expectation that if we had services provided on the front end with evidence-based programs, including specifically for domestic violence, we should limit the number of kids that are coming into foster care. We should not have the trauma of removal from their families if we can provide appropriate services on the front end. And so we've really been challenging judges to think about this by looking at their data and what kinds of cases did they have that were coming in that if they had services, and what services would they need to be able to keep those cases safely and those kids safely with their family. One of the areas that we really have been focusing on is kids who spend less time into care. And ASCAR's data, which is the data that child welfare agencies collect, in the last year showed that over 25,000 children nationally spend less than 30 days in foster care. And you can actually get the data breakdown in your own state. And over 72% of these kids live with somebody they don't even know during that brief stay of less than 30 days. Yet a majority of these kids were returned home. So if you think about who are these kids, why are they coming into care, what was the reason, and how were they able to go home within 30 days? What could we put into place so they never had to experience the trauma of removal? So we encourage people to start looking at that data. Another piece we started encouraging judges to look at just last week with some of our implementation sites is their neglect cases. Neglect cases range from about, the data shows about 74%, and some of our judges say it goes as high as 80% in their jurisdiction.
And you think about what could happen if there was intervention, as Connie calls it, for that 74% or 75% of the kids that the problem is neglect rather than abuse or sexual abuse. That means that there is more time, resource, and the ability to really serve the families that are in most need of intervention. Those are the ones we would want to have protection for the children if we can do the prevention work up front for the lion's share of those who are in the neglect category.
Or those neglect cases that are really complex, that have multiple needs, that have substance abuse and mental health and other issues that maybe need some type of court oversight, but don't necessarily need removal.
Now, one of the things when thinking about you all who are on this webinar and the numbers of you all who are from the advocacy community, as you're working with your survivor clients, these are the kinds of things that you can intercede about with your local agency if there are rumblings about you have to go get a CPO or we're going to remove the kid. Start talking to folks about how this is not necessarily the way to serve children and families when there is domestic violence as an element.
The other piece we are talking to judges about is there are things that are not in, and this is critical, I think, for many of the people on this webinar. There are things that are not provided in by the feds for funding that many of your families need. And stakeholders like you need to come together and look at what that is. Housing, training, and educational programming. We need to come together as a stakeholder community and say, these are the kinds of things our families need to get back on track, and we need those services for our families. And we can't do it alone.
So when we talk about what you all are probably very familiar with, coordinated community responses, which, you know, has been a staple really in the DV world. Remember, we talked about the Greenbook and there were people missing. What Connie is talking about, let's have a coordinated community response to this intersection here, that why couldn't the police be at the table in these conversations? Why couldn't the Department of Housing in your community be at the table? Why couldn't the Department of Employment Services, the Developmental Disabilities Committee, agencies, because many of the parents have these kinds of issues. Why can't we have a bank of attorneys who are able to file for Social Security and disability and see it all the way through for a parent who appears to be qualified? We're in a place where we can think creatively about opening the door. And not only that, but also the community partners who normally are not at the table because they are not agencies. We have lots of faith community programs that work with this population that our executive agencies and the courts may not know anything about.
Workforce education. Lots of people that we do not bring to the table. Higher education, vocational education, things that will help a survivor and a victim become self-sufficient.
Now, one of the things that we also wanted to make sure we make clear, this Family First is yet another of the many acts that have been layered on top of each other around child welfare since the 1970s. We still are responsible for meeting the legal mandates, and the court is basically the responsible entity of the Adoption Safe Families Act, which is called ASPA, and the Indian Child Welfare Act. These acts, which really place the control of the child welfare cases and their resolution in the hands of the court, whether it's state court or tribal court where it's in Indian country, they still are the law. And we still have to follow all of the procedures and processes. But we do have opportunities here because with the focus on prevention before cases come to court, before a child is removed, the number of children from marginalized communities, and I think Connie mentioned this earlier, we can pretty much guarantee that the disproportionality and overrepresentation of these communities should decrease, just like the numbers went down after the implementation of the Adoption Safe Families Act, when more reunifications happened in communities and adoptions where reunification was not possible move forward at a faster pace. Another opportunity is service providers for DV victims and those responsible for the violence will be working toward family safety as well as child safety. We're talking about preserving family systems alongside presenting safety, permanency, and well-being for children. And the fathers, the mothers, extended family are all part of that circle. Now, collaboration we talked about new practices and bringing more people into the tent. But we also have to talk about the fact that systems interventions with families may work to ensure that the family is considered a whole unit and no longer considered the sum of its parts. So we are talking about the family and their definition of what family is to them. We talked a bit about fathers. They'll be encouraged to participate in programs that will address the use of violence and be encouraged to be involved in the lives of their children. Much in the batterer intervention arena now is talking about how do you motivate fathers. And one of the ways that they are finding you motivate fathers is they want to be good fathers, regardless of what their relationship may be with the mom. And that may be a motivation to stop the violence or not extend it to yet another person. The person responsible for the violence will be held accountable, but also be held responsible. And the responsibility piece of it, including that motivation I spoke of earlier, may be the thing that encourages behavioral change. A key component of every element of Family First is family engagement. That means the voice of children, voice of survivors, and voices of those who are part of that family circle, including the person responsible for the violence, as long as it's in an appropriate way.
One key piece that is not part of Family First, but what I wanted to share with you today, because I think it has a key piece in helping this particular population, is some new funding, also from Title IV-E, for representation. There is a policy change that now allows costs for attorneys, for parents, for kids, and for agencies. Agencies already could draw down on Title IV-E. But as you see from the actual wording here, it is for legal representation for a candidate for foster care, which we said is somebody who could be at risk of foster care. And it is for the child's parents to prepare for and participate in all stages. So the way this was intended is you can possibly have attorneys pre-petition. This is huge. So we have examples where we have legal clinics that have worked with the agency and contracted out with the 4E agency to provide legal services for parents to help them with legal issues that if they had not had help with, they might have ended up in foster care. How this can help your DV clients, they could help them file a protective order. They could help them with their housing issues. They can help them with a number of things that are impediments to their having a safe and stable home for their child. So this, to me, is a game changer. Not only are they going to be able to draw down these funds to be able to help them in the legal proceeding, but they can help them pre-court. And there are examples of these. The first document that I've given you a cite to is actually some studies that the Children's Bureau has done about high-quality legal representation, where they have done studies that if you have high-quality representation, it actually saves money and it provides better outcomes. And then the second one is this Title 4E change. This is effective now. I was told just the other day that Louisiana is the first state that just put in for their Title 4E plan to draw down these funds. It is a 50-50 match. It does have the AFDC federal requirement income eligibility, so people are trying to figure that out. It is a state match. So for states that are already putting money into their representation, it is that state match that they can use for the 50% match. So states are trying to figure out how to do this. I encourage for courts to take a lead on this, for you to encourage and ask, how are we doing this in our state? Ask, what are we doing to get our parents better representation, not only during the proceedings, but before the proceedings. Many states are looking, say your state has already parent representation before, during the proceedings, can we now get it before the proceedings? Can we get multidisciplinary teams so that we have survivors, the mentors? Can we have a multidisciplinary team? Because what they're looking for is, we're not supplementing what you already have. We're asking you to go higher and be bold and do better stuff. So to me, this is one of the things that I think can really make a difference for a lot of our parents.
Now, one of the things that when you think about the legal representation and this new opportunity, you can envision that, let's say that a family that you may be working with is in a position where the agency has gotten a complaint, and they end up having representation prior to the kids being removed. That representation helps to shape the prevention plan that must be developed under the Prevention Services Act. And that plan will be available if removal is necessary for the court to actually have something more than we think something happened here, that they can use to determine what's next for this family. And that what's next may be the children aren't removed, but the court is supervising the change process, and the prevention plan during that 12 months of prevention will be the basis for moving the case forward. We have never had that kind of depth if this actually is implemented in the way that Congress intended. Now, what we'd like to do is a few minutes more, and give you a few minutes. If you have questions, can you put them in the chat, and we'll be monitoring them and try to answer anything that we can here today.
We'd also like to let you know that we have an article, too, that Judge House and I wrote that describes the Family First Prevention Services Act, that if you're calling our office and requesting the Greenbook, feel free to also ask for that as well. It's the Family First Prevention Services Act, and we'll let our staff know that there may be some calls requesting those, along with the Greenbook.
They used to say that silence is golden, so I hope you're framing your questions.
There is also a website, familiesfirstact.org, that you can go to that has a lot of resources.
That's familyfirst.org. We have lots of typing going on, folks. This is great. Okay, we have a question here. Who is the best person, agency to contact for implementation? Go ahead, Connie.
Obviously, the person who's going to know the most is the child welfare director, but you could start with, in your own community, asking the supervisors, ask your caseworkers first, ask your supervisors, but your child welfare director will be the person to know. I always encourage people to find out who is the Title IV-E person in their state. Every state has somebody that's in charge of the Title IV-E, because most of this piece with prevention is tied to their Title IV-E, and they are in the know about how this is going to be done. That's another person that's going to be in the know, but their child welfare director in their state will be in the know about how they're rolling this out. A lot of states have assistant directors that are over the field or over contracts. They would also be in the know about how they're going to do some of the programs, so that would be another person to look for. Most states will have a website, and you could go to their website and look at how their states are, how they do their structure, and how they have their executive and with contact information, with emails and such. So you could look at that. CIP, court improvement people, you could go to the state judiciary webpage, and every state has a court improvement program director. And usually you can find that at, through the Administrative Office of the Courts. But if you just go to a state judiciary webpage, you can find that as well.
I don't know how much information you'll get, but I would encourage the advocates on this call to check in with the state coalition, Domestic Violence Coalition, to see whether they're engaged in conversation about the intersection of child welfare, domestic violence, and these new prevention and reunification activities. You know, you guys do the work, so it would be great to just begin the talk. Now, somebody has asked, how long has this program been around? The Act passed in 2018, and I think, as Connie said, there are some time frames for states to get their plans together and begin implementation. But that list of states that's in the PowerPoint, most of them are starting in mid-October or early 2020. They've already signed on. So you can reference that in case you're in one of those locations. Now, we have another question. Many of my clients are told to file a CPO or their children will be removed. You mentioned this briefly earlier, but how would you recommend pushing back against CPOs as the only path to safety for a family? This is a very difficult question, but you probably know, some of you may know, that there's a lot of conversation and hope that this prevention move will help us get out of that either-or dynamic that we've been in. And I can't tell you how to do it, but it's part of the conversation that needs to be had in a collaborative way with child welfare, with the social workers, as well as with the victims, because their autonomy has been taken away because they have to choose between lots of different motivations that they may have not to get a CPO, including housing, versus having the removal. And that is a terrible position. And I think people are starting to realize that that's a terrible position to put survivors and their families in. So you have to keep talking about this is really not considered the best way to go, and maybe even have conversation about how your advocacy community begins to communicate with survivors about how they can communicate with child welfare workers. This is one of the benefits of that peer mentoring process that is a key component of this new act.
Another piece is I think many people are realizing that most families, if they can, it's better for kids and families to, if they can, rehabilitate, to be together in some form or fashion. And if we can get to that point and how they can communicate and be together in some form or fashion is best for kids and families. Also, some states have been pretty creative in saying you don't have to get a CPO, but maybe the person who's battered needs to leave the house for a period of time if that's what the survivor and the child need.
Now, one of the things that is part of this act is re-emphasizing the role of relatives and kin. And you all, as advocates, can work with your clients to see whether there is a family member that can keep both your client and the child safe while the cooling off and the processes begin, if they don't want to get a civil protection order because they don't want to do that. They think it's not going to make them safe. It also means that there has to be a process for safety planning when we have these cases at the intersection of child welfare and domestic violence, that I don't know whether we have effectively done that in this context. So there are lots of opportunities there for all sides of the family assistance that we've been kind of trying to do, and now we have an opportunity to do it more in a collaborative and cohesive way.
And I think the key there is the safety planning has to involve the family in helping to develop that safety plan. It's not the agency telling the family what that safety plan is.
And in fact, your question about go get a CPO is I know you all have probably words for it that I would not want to use, but it's a lazy way of believing you have created a safety plan by getting that piece of paper. And that is not what safety planning is for the child or for the survivor.
So it's really engaging the family in what that safety plan looks like and how it will actually be actualized.
Okay, we have a question. What is the latest report on the Greenbook and models? The Greenbook itself is still holding up, and all that we're talking about in terms of collaboration is still at the heart of the work that's been done over the 20 years. If you want to get a retrospective over what that 20 years has been and where people think it should go next, the Council is publishing an anniversary journal at the end of the year. You can keep your eyes open for it on our website, which I think you'll all receive the site earlier in this webinar. There will be some serious looks at did it do any good and where do we go next, and it helps that we are talking about a legislative process and funding that back 20 years ago did not exist. And it'll be interesting to see whether the Family First will end up offering us opportunities that we did not have before.
Any other thoughts, suggestions, or questions?
Well, I think again, the silence is speaking. Thank you very much for joining us today. It has been a pleasure having this conversation.
And please feel